That is a good practice, but I would say start preparing for your case immediately. And a lot of times the cases that we bring are not, they often are as a result of continuous violations, those strategic cases, and that's why we call them strategic cases. You've been seeing, for example, FGM is rampant, nothing is happening, there is a law, there is no implementation, no protection, nothing. So it's not one case that you've seen a pattern. You've seen, for example, in Kenya, one of the things that we're really battling with is matrimonial property. We actually do not have good precedents on matrimonial property, which is at the level of the Supreme Court. You have different decisions coming out. This one says equal contribution. This other one says you don't need to show financial contribution. So it's so that's a prime case that can be taken to the African Commission, for instance. Yeah, and we had wanted to in Kenya, but we were locked out for some reason. So I don't want to say strictly that there is a time period, but the thing is, immediately you've started the national process, then there is no time limitation. Yeah? So that you won't be told you need to have exhausted local remedies within this period. No. But as long as you can show after the last decision that has been issued, you did not take long. So here we can use the 60-day period as some guidance. You want to say something?
ماذا عن الدول التي لم توافق هذه الاتفاقية؟ ماذا عن الدول التي لم توافق هذه الاتفاقية؟ كيف ترفع قضاياها في هذه المحكمة؟ فهمت؟
Okay, that's a very good question. So, so you can only bring a case against a violation of a right provided in a treaty that your country has ratified. The protocol, for example, your country has not ratified. Yeah, the Maputo Protocol. You can, but it has signed. It has signed, but not ratified. So, under customary international law, yesterday, you may remember that I gave the difference between signing and ratification. So when you sign, it means you're committed not to go against that protocol. But it doesn't mean that you are bound completely. But you align yourself with the spirit and the intention of that particular treaty. So in the case of Somalia, you can argue that Somalia has signed the Maputo Protocol, it has ratified all these other instruments, and therefore has signaled an intention to abide by international law, regional law in the case of the Maputo Protocol. But that cannot be the only basis. So it will be in addition to. So you can speak about the violation of your national laws. That is the starting point. In fact, when you're drafting a case, whether to the court, to the commission, to the committee, you must demonstrate that there is also a violation, primarily of your national law, because that's what your government has actually committed to at national level before even going to the regional level. But it doesn't mean that in the case of countries that do not have, say, a law prohibiting FGM, and your government has signed the Maputo Protocol, that you can't use that to allege violation. So you don't necessarily have to have to show the national law, but that is where you start. If there is a national law, you start by showing that that national law has been violated, then you go to the regional and the international. Yeah? So the idea here is to demonstrate that the government is bound by all these legal instruments and has failed to comply. Yes.
All right. So my question is on the exhaustion of local remedies. So you said that remedies are have to be exhausted. They have to be available, effective, and adequate. My question is, what measure is adequacy? How do you know that this remedy is adequate enough?
Okay. Let me think of an example. I'll use the Ethiopia case at the African Commission that we talked about. Remember, I said that there had been attempts to settle it out of court, out of the outside of the commission, and for a violation of defilement and forced marriage. The government was offering a house and employment to this young girl. Is that adequate remedy for defilement? It's not, right? Is it adequate that she would feel safe going to live in a house where when her perpetrator and co-perpetrators are out? It wouldn't. So that's inadequate. Yeah. So you can then say clearly this is not there. What other example would I give? So let's say you have gone to court to challenge. Give me a violation. FGM. Okay. So FGM. And the government says, okay, so how many types of FGM do we have? 4, right? There are some schools of thought that have been saying, actually FGM, if it's done under sanitary conditions within a hospital or something, it is okay. Yeah. So you go to court, and in your country, probably the type of FGM that's practiced is type 1 or type 2. And the court decides, okay, we will not allow type 1 and type 2, but people can do type 3 and 4, so long as it's done within a hospital. Is that adequate? Is that a remedy? So then you can now challenge it on the basis of inadequacy. Yeah. Also, effectiveness. So what would be an effective remedy is one that the government can actually implement. So they can't, for example, this is an absurd example that I'm giving, but they can't say, okay, so how about you go to Uganda, then when you're there, we'll protect you. I mean, it doesn't make sense. It's your responsibility, you, Mr. whichever country. It also cannot say something like, okay, we realize that you're a survivor of FGM. We're going to pay you 150,000 USD, but we'll pay you this money when you are 68 years old. Yeah, absurd examples, but yes, you get the point. Yeah, okay. So yes.
Are we using your time? We are using your time, yeah, with so many questions. Okay, so my 2 questions are again on the exhaustion of national remedies. So most of the conflict-related sexual violence or any other gender-based violence sometimes or most of the time is perpetrated by people who are still in power. So how could you really think to prosecute or bring a charge against a person who is still in power? It is really impossible. That's what we are facing currently in Ethiopia. And the other is, if you do to prosecute, for instance, there is an exception. Let's assume in this African regional mechanisms, there is an exception that says if the perpetrator is in power and you can come over in the region. So what kind of regional protection mechanisms are available to file a case while you are living in the same country with the perpetrator? For the witness, for the victim, even for the organizations. If EULA, for instance, sues somebody who is in power, how can this African court or any regional mechanism available so far can protect any organization?
Fantastic question. In fact, I feel like you've seen my presentation, because this slide and like two more that I have, you see these cases that I've cited here. The case of Jawara versus the Gambia is exactly speaking to what you're saying, Wineshet. Because part of part of exhaustion of remedies includes that you must be able to access those remedies, yeah? And if you're not able to, then you can show that at the time you weren't able to exhaust remedies. Same case as with where we have a conflict and systems are suspended, there will be no question as to the situation showing that you would not have been able to exhaust local remedies. So these examples here actually show situations where the commission or the court have actually done away with the requirement for exhaustion of local remedies. In the case, so if they are poor, like in the case of Purohit versus the Gambia, I mean, you didn't have the funds to go through a lengthy national process. You can show that as a reason for failure to exhaust local remedies. In the case of Free Legal Assistance Group versus Zaire, which is now DRC, that was the time for Mobutu. And we all know Mobutu Sese Seko. Oh, I hope you do. So Mobutu Sese Seko was this a very bad dictator. And at that time, you couldn't do anything against him, yeah? And there were mass violations of human rights. And so this group went to the commission and said, we couldn't exhaust local remedies because look who was in power. Same thing in Nigeria, if domestic jurisdiction outs the jurisdiction of national courts. So that was a case by a journalist. And then if those rights are not guaranteed by domestic laws, so for instance, your country has ratified the Maputo Protocol, for instance, but you don't have national law that provides for protection of widows' rights, yeah, which is a unique aspect of the Maputo Protocol. You can then use that to show, I mean, look, Mr. ACHPR, even if I went through the national process, this right is not recognized under our national laws. So we've come directly to you. This was a case of community rights, Serac versus Nigeria, so you'll get to read it. And then if it's physically dangerous for the complainant to return in order to exhaust remedies. So Jawara was a former president of the Gambia, ousted through a coup. He obviously couldn't go back to his country because the person who ousted him was another crazy man called Yaya Jammeh. So he couldn't go back to his country, yeah? Same for the case of Abu Bakr versus Ghana. And then if the complaint involves an impractical number of potential plaintiffs, so meaning there are gross violations, it is rampant, so many people are affected by it, and they all can't exhaust local remedies. That was the case of the African Institute versus Guinea. And then if the procedure of obtaining domestic remedy will be unduly prolonged. So we all know that our governments, no worries, you'll get the slides, I promise. We all know that our governments are the stars of delay, yeah? They will look for every reason not to implement. They look for every reason, you know, whether they'll come with a preliminary objection, or they will even send the judge to a training when your case is coming up for hearing. The prosecutor will fall ill, they will change prosecutors, or the state council will be transferred. These guys are the stars of delay. So if you can actually demonstrate that on average, like a case in your country takes about 6-8 years to go through one court, then you can show that this process, it will be so long. And especially where you're seeking for interlocutory orders, that's a very good ground to, you know, waive the exhaustion of local remedies. And of course, if it defies logic, if it's simply logical to require the exhaustion of the local remedy. Yeah. So in the case of systems are not working, or the government is just not cooperating. Yes, the government never cooperates though. Anyway, so let's now look at how you file cases before this. So the first one is the African Commission, sorry. At the African Commission, how you submit this is very simple. Through mail, email, or by registered mail. You can physically deliver it at the seat of the commission through the registrar. So you go to Banjul, which means that you could be attending the African Commission session and you decide to use that as the time to file your case. But you can also do all three, just to be sure that it actually reached. Sorry. So they have new rules of procedure that were amended in 2020. You need to look at the rules of procedures for all of these human rights bodies. Then for the committee, it's the same thing, and the same also for the African Court, sorry. Yeah. Then the format is not very different before all these treaty bodies. But for the African Commission, they have a template. Again, when you look at the rules of procedure and the practice directives of 2020, they guide you through that process. So there's a template, which is the one I had wanted us to use as a group exercise, but I don't think we'll have time. I'll send it to you as well. Then for the committee, you also need to follow the guidelines that are outlined there. For the court is where it's a little complicated. So you have to make that complaint through the form that is provided by the registry. And you also have to follow the rules of procedure that have been outlined there. In terms of strictness, and Esther will also add onto this, the court is more strict in terms of compliance than the committee and the commission. So for the court, you really have to be sure that you're filling in the right form, because again, you might be using the wrong form, and that you're filling it according to that guidance that has been provided in the rules. And then of course, you then submit it to the registry. Let me just add here that for some of the sub-regional courts at the regional economic community levels, the ECOWAS, the East African Court of Justice, if you are taking a case there, you don't need to physically go to, where is East African Court? Arusha. The term just disappeared in my head. You don't have to go to Arusha. You can go to your local high court registry and file your complaint there. So that's a unique thing for the sub-regional mechanisms. And then locus. So you need to show that you have locus standi to come before this court. On what basis are you approaching the court, the commission, or the committee? And for the commission, any person, either by yourself or on behalf of someone else, you can file a complaint. Member states also can do that. For the committee, it's any individual or group of natural or legal persons, including children. Again, quite interesting that a child can actually, file before the committee. And then state parties, intergovernmental organizations, so your IGAD and whichever, or an NGO that is recognized by any AU member state, a state party to the Charter or the United Nations Charter on the Rights of the Child, or any specialized organ or agency of the AU and UN. So we can see it's virtually open to anyone. Yes.
So my question is on children and their capacity to sue. So do they take in the format of next friend as it is in the local?
Yes, they do. So a child would need to have a next friend, but they would, they are able to access the court. So it wouldn't be that. I mean, mostly like in our national jurisdictions, it's the same thing. So you sue through a next friend. There's a case, one famous case by the committee on the Nubian children's rights in Kenya. It's a citizenship case. That's an interesting one that you can use to just see the procedure that they follow. And then for the court, you have to follow the protocol, what the protocol establishing the African court says, specifically Article 5, which is where it stated who has standing. So remember, yesterday I said that the African Commission can actually refer a case to the committee, to the court. Yeah. The example that we said, like the Kenyan case of the Ogiek. So a case that is filed at the commission then forwards it to court. So the commission therefore has special standing and that complementarity relationship with the African court. Any state party, primarily the court is most of the cases that are before the court are between governments. So state versus state. Of course, which has lodged a complaint at the commission, and then any state party against the complainant, any state party against which a complaint has been lodged at the African Commission. So a state can, in the case of DRC, a case that we recently got a decision on, DRC could have gone to the commission, to the court after we filed the case at the commission. Yeah. So as an opportunity that exists. And then a state party. So I think someone yesterday was asking a question about, I can't remember very clearly, but it was around the lines of if your rights are violated. I think was it you or someone here? If your rights are, if another country is an aggressor of another country's citizens, yeah, what can that country do? So I will use my country as an example, but do not quote me. So Kenya, is an aggressor or a contributor. This is fictional, please, guys. I want to return home. Fictional, please, for learning purposes. So Kenya is a contributor in some way to the war in Sudan, and therefore is contributing to the violations there, whether it is death, rape, whatever, by contributing, whatever they're doing. Then Sudan, if systems were working, Sudan can actually sue at the African court on the basis of violations that have been committed against its citizens. Yeah? Do not quote me. Scrap that.
Yeah, the example is that Sudan is not did not ratify any of the treaty. So that was the
okay. So I have misappropriated that example. I'm sorry.
The point is, the example is okay. So the question was whether Sudan, because Sudan is not part of the system, can do it, can sue Kenya. So is that yes or no? I don't know.
But Sudan is a party to the African court. I think they have ratified the protocol. Have they, Esther? The protocol establishing the court? They haven't? Okay. Okay. So in this case, for learning purposes, we're assuming that they have. This example I gave, this last one. Yes. If they had, they're a party, then they can do that. If they are not, hey. I will think about it more and come back to you.
How about Somaliland? Somaliland is a facto state. They say we are sovereign state. We are not part of Somalia. And our constitution say Somaliland respect the treaties and conventions about the human rights. So if I wanted to submit my case this court, is there any mechanism that help me, yeah, for my case? Because we are not part of this, but our constitution say we respect it. So is that enough, or we need to be part of the commission? And
Now,
okay. I remember yesterday, Catherine talking about it's also fiction, huh? Remember I'm in Uganda. Okay, the case of, for example, Uganda and South Sudan, with the issues happening nowadays, I'm sure some people are following at the border. Then, yeah, and she mentioned yesterday. So the commander in chief and the commander in chief of South Sudan and Uganda said, and they were like, these are issues between individuals, army. This can be handled. We have a very long history and blah blah. Now, assuming that because this issue is happening in a area on the border in Kajukeji, can somebody from there, apart from what the government is doing here and there, sue the government of Uganda because it's happening along the border?
for that one, yes, because then Uganda is a state party, yeah. So it's a yes, a short answer, yes. Okay, these hands are many. I think she had her hand up first, and then.
So thank you so much. I want to actually want for us to discuss on it because we have this case on conflict-related sexual violence. Typically, during the Tigray, the war that we had in north part, the Eritrean troops were the main actors of the conflict-related sexual violence. So in this case, Eritrea has never been part of any any kind of African, initiatives, treaties, or anything like. So in this case, for instance, if we want to bring a case against Eritrea, how are we going to do it?
Okay.
Okay. Oh, yeah, it works. So mine is just like everyone else's. Can citizens of non-ratifying states approach the court or the commission?
Let me step in for some of the questions. So the way it works is that even if your country has not ratified the protocol establishing the court, as long as they're members of the AU, if you go through the commission can then refer this case to the court. And in this event, because it's the commission that now is prosecuting on your behalf, then your country will still fall under the jurisdiction of the court. I hope that is clear. Yes. So you go through the commission because as long as your country is a member of the AU, then it is subject to the African Commission. And then the African Commission goes to the court on your behalf now.
Yes, fantastic. Thanks. Because the commission, remember that special relationship that they have. However, now to answer your question, Somaliland is not a member of the AU. So as much as it is described as a sovereign state, then it does not have that standing because it's not a member of the AU. Yeah. But yes, then at national level, it's maybe no. let me not be distracted. But yes, shall we proceed, please? But thank you. I really love these questions, and was I given homework? I think I took homework somewhere. And then for admissibility, we'll quickly run through this because we've been talking about it yesterday, today, and we'll also do a bit of exercise on that. So when you're doing your submission, and at the African, across all these human rights bodies, there are basic things that are the same all through. So not using disparaging language. You can't like go there and say our stupid government did not do this. You can't say those things, yeah? And then you can't just rely on mass media, like you have to have facts. And then it should be submitted within reasonable time. So back to your question about what's the time limit. So the test of reasonability is what is applied here. And there shouldn't be another case that is pending in any other, judicial body. So you can't file a case at the African Commission and file another one at the African Court. Yeah. Or if there are two people or two organizations that have gone and filed similar cases, you can't file that. That happened with us at Equality Now. Another organization also had gone to the African Court in respect of the return to school policy in Tanzania. Then, of course, all of this must first be must be compatible with the AU Constitutive Act, because that's the mother, that's the foundation, as we said yesterday. And then, so you start with the Constitutive Act because that is what recognizes the state against which you are filing the case. And then now you use the treaty that has established that treaty body. So for the African Commission, that's the African Charter. For the committee, that's the African Charter on the Rights and Welfare of the Child. For the African Court, that is the African Charter as well as the protocol establishing the court. Yeah. Then the procedures of determining these cases are as per the rules that all these treaty bodies have established. At the beginning, everything starts from the registry, just like in our courts. So the registry will peruse all your documents and see whether they are ready to proceed before they can even proceed through the different processes as provided under this. So for the commission and the committee, the rules are slightly different, not very different, but slightly different from the African court. The African court will follow just the way we know a normal court process goes. You have interlocutory motions, you have right to reply, you can file a rejoinder, and then you go for oral hearings. The same also for the other bodies, but they all have to go through a process of admissibility. So you file, then it is reviewed. Admissibility then means that, yes, it is fit to proceed as a case. So it's at the admissibility stage. Once you've received the decision on admissibility, that's when you can say this case is actually proceeding. A lot of cases are actually thrown out at the admissibility stage because either they do not comply with the filing requirements, or there isn't substantive evidence of a violation of a right, or it is before the wrong body, which is something that's again decided on jurisdiction. Yeah. And then I think yesterday Esther also went through the remedies that are available. So how do you structure your complaint? Remember, these are general guidance. This is just general guidance. Every organ, every treaty body, the three that we've mentioned, they have their own procedures, they have their own unique forms. But these are the same things that you will find. So you need to give your details, so you can't file a case as anonymous. You can't use initials, for instance. If you do, then you need an order for that to use to be anonymous, right? Just like we do in our normal courts. And then the name of the respondent state must be indicated. So you have to use the name of the state as is known by the AU. So which example can I use? So you can't like go and write, oh yeah, there's this interesting country that changed its name recently. Do we know it? Lesotho. They call themselves Eswatini. Swaziland, sorry. Swaziland, Eswatini. So which name would you use? You have to use the name that the AU uses. Yeah? If it is Ethiopia, we all call Ethiopia Ethiopia, but we should use the full name. Federal, yeah? You use Republic of Kenya, whatever. You can't like just go Ethiopia. You can't like just go which other country. You can't say DRC. You have to say Democratic Republic of the Congo. So in full as known by the AU. And then proof of exhaustion of local remedies or inability to exhaust, then you attach. So if you have gone through all the court processes, then attach all those judgments from the High Court, Court of Appeal, Supreme Court. Show that you have actually gone through. These are the orders that you got. You are not happy, you appeal, and all that. And then a summary of the facts. So providing a chronological account of how you've reached going to the African Commission or the African Committee or the at the court. So you must state clearly, this is why we are before the court. So the summary of facts is not your application. It is just a summary of your case, right? So don't put the summary of facts and forget to do the form. Or don't do the form and forget to do the summary of facts. Those are two different documents. Then substantive allegations. So you need to tie an allegation to a right that is in a treaty that is recognized by the AU and that the state party against which you're filing has signed or ratified. Then provide your evidence again. And remember what I said, like bring all your evidence. You'd rather have more evidence than insufficient evidence. And then be clear about your remedies or the prayers. Now, when you're crafting your remedies and prayers, you need to think about, and this is something that I keep emphasizing, think about implementation of that decision. Yeah? Because if you go and seek for, let me see what kind of remedies we can say. Say it's a violation against a 16-year-old girl and you're saying, actually, it's not even safe for this girl to remain in Kenya. Let the African Commission order the Kenyan government to relocate this girl to Canada. Yeah, so that's the prayer that you have asked. How are you going to enforce that order even if it's given to you? You have no way of enforcing, you have no way of urging the government to enforce, yeah? So think about it. Think about the end as you're starting, as I've said. What outcome do you want? How do you want to craft that outcome? How are you going to follow up on implementation so that you don't end up with a decision that you cannot implement? I talked about this case yesterday. I'll share this again with you guys, but how am I doing for time, Lynette? Okay. So we talked about this case. This is the Equality Now and EULA versus the Federal Republic of Ethiopia. You see what I told you? So yes, at the commission, it's a communication rather than a case. That's how they call it. So in this case, for instance, going by, if you follow this structure, you'll see that, well, you won't see 3, but you'll see 4, 5, 6, 7, yeah? So the issue is there. You have your facts, the process. So you're seeing what happened at the national level and how you're actually reaching the commission. But this is a summary of the case. I'm just using it as an example to show that structure. Then the findings would be on the basis of the violations that we alleged, and the remedies are what then the commission issued. This was quite a very good decision because the commission ordered reparations and systemic remedies, including a payment of 150,000 USD as compensation to to this young girl. Then at the African Committee, the example of the Legal and Human Rights Center, the Center for Reproductive Rights, this is the case that I was telling you guys that we, Equality Now, also wanted to be a part, had filed, and then this case was already in place, so we didn't proceed with it. So again, you see, you're able to tell what the issues are, the facts, the process, the findings of the violations, and the remedies that have been given. Yeah. So in this case, Tanzania was ordered to repeal that law that was there, which is that pregnant girls cannot go back to school. It actually did repeal, but what they did was to say that we'll have special classes for adolescent mothers. Was that right? Do you think that was right? They said, okay, you can come back to school, but because we don't want you to teach other girls your bad behavior, please sit in your own class. So it was like really crazy. So in effect, it's a further violation. Yeah. So in effect, that rule is still there. Like this decision hasn't been fully implemented. Another case at the East African Justice, this one is still ongoing. It's against Uganda with regards to the restrictive abortion laws and in violation of the protocol and CEDAW. So it's very similar to a Kenyan case that I talked about yesterday. I think we might also end up appealing to, not appealing, but filing a case at the regional level. So this case is still ongoing. Now, some of this that I talked about initially when I was showing the thing about exhausting local remedies, I've put them here. You'll see a few here. So SERAC versus Nigeria, these are landmark from the commission. The Nigerian government was found responsible for environmental destruction and repression in Ogoniland. So you remember I talked about group rights yesterday when I was introducing the African Charter. Yeah. So this is an example of group rights, environmental rights. Okay, sorry, I have caught the bad behavior of my namesake of speaking fast. Sorry, interpreters. I think I'm rushing against time now. Oh, really? You always do. Okay. Okay. Now you'll come back and do it. So again, the slides will be made available to you, but I just thought that it would be helpful to show the legal impact of these cases. So the SERAC case for the people in Ogoniland was the first to affirm the right to a healthy environment and group rights as a right under the charter. So that people's now makes sense, I hope. The Endorois community versus Kenya, I talked about this yesterday, a decision in 2010 that has yet to be implemented. So it defined indigenous people's rights and the right to development and how that impacts and the need for public participation or consultation with groups that are in a region or an area where the government seeks to have some development. And then the media rights agenda versus Nigeria, I talked about this, which was around, this journalist had been detained for like 10 years with no trial. So obviously then he couldn't exhaust local remedies because of the situation prevailing. And then the Free Legal Assistance Group versus Zaire affirmed multiple charter rights, including education, health, and liberty. Again, remember that when I was speaking about this case, I said that local remedies couldn't be exerted for two reasons. A, the repressive regime, but also because there was mass violation. It's like this guy just violated every article in the charter, didn't care. And so the commission found that he was in violation. Some of the landmark case judgments that we've had from the African court include the one that Esther talked about yesterday, APDF and IHRDA versus Mali, regarding the minimum age of marriage and the violation that was perpetuated by the family code. this decision is impactful because it reforms the need, or it orders the need to align national law with the Maputo Protocol and CEDAW. Then Tanganyika Law Society versus Tanzania. This was a ban on independent candidates in elections, and it affirmed political participation rights and democratic principles. And then Konate versus Burkina Faso. Again, this journalist had been jailed, couldn't access local remedies, and was actually arrested for defamation. I think most countries in Africa have these criminal defamation laws, and it basically targets freedom of speech and expression. And then the Mtikila versus Tanzania, again on electoral rights and political participation, and the Guinea case. Yeah. So this is where the English disappeared. I said the pros and cons. So it's not quite pros and cons. So don't think about pros and cons. I think after tea I will have inspiration, so I will correct this. But why get into litigation, strategic litigation? As we've demonstrated in these cases, yeah, the legal impact here, the cases at the commission, the cases at the court, you can see that it's groundbreaking in the way these cases have actually expounded on rights, expounded the space for using these treaties, yeah? So that's why we're saying that strategic litigation is important for precedent. And the thing to always remember about strategic litigation is that, yes, you might have that one representative complainant, but the ripple effect is massive. It's not just about that one individual, it's about others who might be suffering the same violation, or to prevent others from suffering that same violation in future. When you are doing your cases even at the national level, you always rely on precedent, right? And it's important when you're relying on precedent because you're able to see what kind of decisions actually come from these courts. If you used the Ethiopia case, for example, yeah, down there, the remedies that were given, the African Commission gave 150,000 USD. So if you're looking for monetary compensation at the African Commission, you already know that the Commission has previously given 150,000. So you can say, okay, we want to ask for 200,000 as an example. And then, as I said, it's not about that one individual, it's about establishing change and bringing about change for women and girls. So again, the Mali case, it was one law that was contravening the minimum age of marriage provisions in CEDAW and in the Maputo Protocol, but its effect wasn't just on one person, it's on the entire country. And so that decision, because the court ordered national law reform, it means that it contributed to large-scale policy or legislative changes. Same case as with Ethiopia, during the pendency of the case, they actually amended the Marry Your Rapist law, right? And then it also raises awareness and media attention because maybe one time FIDA will invite me to come and talk about strategic litigation and do proper exercises. But yeah, so it's a whole thing, not just the court, but winning your case in the public court is also very important because a lot of times you'll file a case, but the communities that you're in will actually fight you because they'll be like, why are you suing the government? This FGM thing, we've been doing it all these years. Why are you going to sue the government? Yeah. But you must use that opportunity to raise awareness on that issue and on other rights, of course, without contravening the sub judice rules. What we're calling here the cons, but not quite the cons, but just like those uncomfortable truths about is that you may run the risk of re-traumatizing the survivors. Yeah. Because by the time you build your case to be able to present it to any of these three bodies, you have interviewed so many survivors. You have interviewed them several times and they keep reliving the violations so that you get your case right. Yeah. So you need to think about psychosocial support for survivors and working with them that entire journey, even if it means relocating them out of the country. Yeah. And then potential backlash, obviously, from anti-rights groups, but also from our communities. Then bad precedent or retrogressive judgments. We've seen this in most of our national courts, where there's one time in Kenya, we were very excited about our constitution. Then it was still new, and nowadays it's old. So this is 2012, and I was then working for the Kenya Human Rights Commission, and we have this beautiful chapter in our constitution on leadership and integrity that says that you cannot vie for public office if you are facing a charge of an offense whose punishment is more than 6 months. And at the time, there were two naughty characters. Okay, I need to go back home. Two naughty characters, Uhuru Kenyatta and William Ruto, who had been indicted by the ICC. And they had expressed interest in vying for the presidency in 2013. So in 2012, me and some other slightly braver people than me went to court, and we told the High Court, look, you need to stop these people from vying because they're facing charges at the ICC. Minimum sentence, more than 6 months. They do not qualify under our law. And so we presented this whole case and made our arguments. On the day of the judgment, 5 judges, 5 grown-up judges, sat there and they repeated everything we had made in our submissions and everything. And at the end, they told us, no, they have not violated Chapter 6 of the Kenyan Constitution and they can still vie. And also because you people, you have, what is kiherehere? I don't know how to, there's a Swahili word for kiherehere. Yeah, because you guys are know-it-all, it was two leading human rights organizations in Kenya. We were slapped with costs for a public interest case. Now that is very bad precedent because we all know that public interest litigation does not attract costs. You can't, it's for the public interest. So why? Yeah, we've never paid that cost. And so donors also are telling us, please, can you stop doing these kinds of cases because we don't have money to pay you to be paying for costs. So you can see how the courts can really, give very bad judgments. But even for the issues that we're talking about, women's rights, I mentioned the case of Kenya where matrimonial property, I think that's one area where we have very, very bad precedent. Another example is a very recent case that was decided by the African Commission in respect of Nigeria. I will share it with you. It is a very bad decision. It's a very, very bad decision because it takes away from all the gains that we've made under the Maputo Protocol. I'll share that with you as well. And then, of course, you have to prepare for lengthy procedures, implementation gaps, most importantly, implementation gaps. The Ethiopia case that I mentioned, the decision was published after, I think it was after 2 years. I think it was after 2 years, yeah? No, wait, 4 years. 2016 was when the decision was made. And then 2018, there was a decision on review. And 2022 is when that decision was published. But to date, implementation hasn't happened. So that's why I was telling you guys that you need to think about implementation because you only conclude a case, not with the judgment, but with implementation. Yeah? Okay. So I think we take a break here unless there are any questions and then get some energy. Then we'll get to do a bit of group exercise. Do I still have time? I'm assuming. Okay. Yeah? Okay. Thank you. Yes.
Yeah. Okay. I was thinking, like, in the case of Ethiopia, it is something that happens in Somalia. Um, Victims of rape are married off by the rapists every day, and we're struggling with sexual violence in general. We have been struggling for 20 years enacting, sexual offenses bill, um, because there is a customary law is very strong in Somalia, and customary is based on compensations. There's no any punishment in Somalia. And then I was thinking, like, if we can file a case maybe through the commission on these cases as well. Yeah.
So let me ask. So you don't have national law that criminalizes FGM?
We don't have specific laws. We have outdated penal code, but customary law is much stronger. The elders of clans have the right to interfere the court until we are solving this case outside. So they are going to solve the case outside. So it's still, it penalizes about, I think, Yasmin, 5 to, I think, 10 years for rapists, but, it's not accessible because, it's not reaching even the court sometimes. Even if it reaches, the elders have access to withdraw the case outside. And we're trying, to enact the SOP, but religious leaders backlash it. They said it's anti-Islamic, So we are struggling to find local remedies for sexual violence in general, specifically for rape cases.
I want to say that yes, that would be a good case to bring because it actually shows that the law, whichever law is applying, is ineffective to address sexual violence. And sexual violence as a violation is rampant. So part of strategic litigation involves case development. So your case development in this case would be documenting the evidence of the systemic violations, documenting the inability and unwillingness of the system to provide remedies, the ineffectiveness of even enforcement of the 5 or 10 years imprisonment, the interference and heavier hand of the religious leaders in making the court system ineffective. So therefore, you can even argue that the local remedies are ineffective in this case because they have all these gaps. Yeah. And then use that. So when you're thinking about that kind of case, it's more like you're thinking of a class action suit. You need to show that it's widespread, it's rampant, it's systemic, and there is a block in terms of seeking and getting remedies. Yeah. So yes, and you can use national law, the charter, she said. The signature on the protocol itself means something. And I think you've also ratified CEDAW. Ratified CEDAW, no? No? You haven't I thought Sudan is the only one that hasn't ratified CEDAW. Okay. Okay. Yeah. No, I'm saying I thought that it was only. Okay. Good. Yes.
Okay. هنا في السودان كمية من الناس قاعدين في السجن مستنين الإعدام. نسبة للحرق في السودان في عندنا قضايا بتهمة التمرد ضد الدولة. تمت محاكمة الأشخاص دول بقواعد إجرائية وقانونية غير عادلة أو مخالفة لدستور السودان. حاليا في السودان ما عندنا محكمة دستورية، فبالتالي ما قادرين نطعن في القوانين دي بعدم دستوريتها. فسؤالي المباشر هو أنا ممكن ألجأ للجنة الإفريقية دي وأطعن في القوانين دي، ولا أنا بس إلا أقدم
قضايا ضد أشخاص بعينهم. وسؤالي الثاني، اللي بيخلي الدولة شنو تكون ملزمة بقرارات اللجنة الإفريقية دي؟ يعني مثلا في قضايا اترفعت للجنة من التسعينات واللجنة وصت بتغيير أو تعديل قوانين والحاجة دي ما حصلت. تقريبا يعني عندنا قضية اترفعت في اللجنة في التسعينات كان تم ذكرها أمس حقت دوبولو في 2000 تقريبا، والقوانين ما يتعدل إلا بعد 2020 بعد الثورة. فبالتالي أنا حسيت إنه لجونا للجنة ما هو ما قادرة ألقى المصطلح، لكن ما أعرف الحاجة اللي بتخلي الدولة هي تكون ملزمة شنو، يعني ما شايفة في إلزامية. يعني إذا أنا قدرت أوضح النقطة بتاعتي. بالنسبة للكيس اللي قال الأستاذ قبل شوية حقت إنه نحن في السودان عندنا تم سن قوانين بتجرم ختان الإناث، لكن السلطة المجتمعية هي أقوى من القانون. يعني بيتم تسوية الكيسات دي خارج الإطار القضائي، والقانون بيجوز الصلح خارج الإطار القضائي. فحاليا الحاجة الوحيدة اللي نحن حاليا ماشيين فيها في السودان إنه نحن بقينا نشتغل في إنه نحن نرفع وعي المجتمع، ونحاول نرفع وعي زعماء العشائر بخطورة ختان الإناث. فبقينا شغالين في الإطارين، الجانب القانوني من الدولة والجانب المجتمعي، لأنه أحيانا حتى لو الدولة هي وقفت معاك وسنت القوانين دي، فأحيانا القوانين هي ذاتها ممكن يتم التحايل عليها. فدي الحاجة حاليا نحن ماشيين فيها في السودان. حتى منظمات المجتمع المدني في السودان حاليا بقت هي ذاتها في ورشة بتعمل ترونيك للشرطة، لقضاء النيابة، للقضاة، فنوعا ما هم بقوا متعاونين ومرنين. شكرا جزيلا.
Thank you. Was there another question before?
طيب أنا بس عايزة أتكلم عن دور الدول في الضغط على السودان عشان تصادق، ودور المنظمات المحلية. فبنلاحظ إنه غياب غياب السودان عن المصادقة ده بيأثر على الالتزامات الإقليمية فيما يختص بحماية حقوق النساء والأطفال. فبما إنه السودان عضو في الاتحاد الأفريقي، الدول المصادقة يمكن أن تضغط عليها، لكن ده ممكن يعتبر انتهاك لمبدأ سيادة الدولة، مبدأ السيادة. عايزة أقارنه بأنه في تصرف اتخذته به اللي هي منظمة محلية. في فتاة هي بنت طفلة مولودة سنة 2000 اسمها أم جمعة من شرق السودان. فلما كان 16 سنة حصلت لها قضية بتاعت مسألة بتاعت اغتصاب من راجل كبير يعني. المهم والدة لجأ للمحاكم المحلية.
The courts referred her to the child courts. The child court convicted the perpetrator and sentenced him to 20 years of prison and with a huge fine. There is the African Center of Justice and Development. He filed a complaint to the African Commission, the African Committee responded and acknowledged that Sudan had shortcomings in protecting children and did not provide the health and psychological support for the child, and decided and decreed some guidelines that Sudan must ratify the act, and there has to be obligations from Sudan in protecting children. Here, I want to say what I want to say. States, party state must pressure Sudan to implement the decisions issued by the African Committee, which was filed by the local NGOs. Thank you so much.